Yeah, so in the argumentative arena of queer justice cases, IHRL is employed regularly to argue that queer people should have access to human rights irrespective of their sexual orientation. And this trend of placing reliance on IHRL and its non-discrimination obligations in cases concerning queer justice has a rich history, starting with the European Court of Human Rights' decision in Dechert v. UK and the Human Rights Committee's landmark decision in Toonen v. Australia against UK and Australia sodomy laws, respectively. Toonen v. Australia specifically marked the genesis of international law discourse, which embraced sexual orientation as a protected ground based on which one cannot be discriminated. Over the years, this discourse percolated into various judgments by courts across the globe decriminalizing homosexual coitus. So in these decriminalization judgments, international law's nod of approval enriched the queer movement's struggle against criminalization in a significant manner. However, in a development sharply contrasting this trend of relying on IHRL, the salutary effects of international law did not travel to judgments that legalized same-sex marriages. Before we move on to a discussion of why this happened, let us explore the ways in which decriminalization judgments and queer marriage equality judgments really engage with international law. While doing so, we will come to see that judgments providing legal recognition to same-sex or queer marriages, which I call marriage equality judgments, engage with obligations under international law differently as compared to decriminalization judgments. So when I studied around 12 decriminalization judgments, I found that their engagement with international law shares two features. Firstly, decriminalization judgments feature a comprehensive analysis of privacy, equality, non-discrimination, and dignity-related themes under international law. This examination is comprehensive and not perfunctory or half-hearted because it meaningfully illuminates the normative content of those international law rights. They do much more than simply citing decisions like Dudgeon, Norris, Modinos, and Toonen. The interpretive exercise of these judgments is often supplemented by a panoply of indicia for the international law position. They cite preambulatory clauses in treaty articles, speeches from UN officials, journal articles, the Yogyakarta principles, general comments, views, and treaty body decisions. Even when decisions like Dudgeon and Toonen are cited, their implications are discussed in detail, and they're used to reject specious arguments by state governments, and they're placed in the wider context of human rights, even though Dudgeon and Toonen do not themselves discuss discrimination and dignity-related themes elaborately. So in this case, in this sense, decriminalization judgments engage with international law in a comprehensive and meaningful manner. Secondly, decriminalization judgments also reveal the significance of international law for rights favoring strategic litigation at the domestic level. This comes out clearly when these judgments hold that the broadening horizons of human rights under international law ought to trickle down and enrich rights under domestic constitutions. So discussion of international law in these cases has served as an exhortation to say, move with the times. That's how the talk of human rights under international law provided an additional reason for rights favoring analysis in decriminalization judgments. Let us now move to marriage equality judgments. The approach that courts around the world have taken in consulting international law to render favorable rulings for same-sex marriage falls under three categories. Group A marriage equality judgments with over 25 judgments lacking comprehensive engagement with international law. Out of these over 25 judgments, only one earmarks some space for a single footnote related to international law. Another marriage equality judgment by South Africa's Constitutional Court reserves a single para for international law, and even in that para, it ends up misquoting the leading international law decision on marriage equality, and in fact states the opposite of what that international law decision actually said. Group B only has 3 judgments which place reliance on international law to meaningfully interpret marriage rights. And Group C has judgments from Costa Rica and Ecuador that comprehensively engage with international law, primarily to insist on compliance with the 2017 advisory opinion of the Inter-American Court of Human Rights in favor of ensuring marriage equality for queer people as a human right. This shows that international human rights law's role in marriage equality judgments is worryingly emaciated. The fact that Group B's judgments have defied this pattern provides little relief because this deviation is the exception. Among other things, all jurisdictions of Group A share one commonality. They're all parties to the ICCPR. This aspect contrasts them with decisions of Group C, which are all rendered by courts of state parties that are additionally subject to the American Convention on Human Rights regime. As we shall see, this attribute is key to discovering the explanation for differential treatment of international law that I've identified. Unlike the ACHR regime, the ICCPR has not had a history of case law favorable to same-sex marriage. In fact, interpreting Article 23 of the ICCPR, the UN Human Rights Committee in Jocelyn v. New Zealand held that New Zealand had not violated the ICCPR by refusing to provide recognition to same-sex marriages. Even when the complainants in Jocelyn claimed a violation of Articles 2 and 26 of the ICCPR on the ground that New Zealand's failure to recognize same-sex marriage discriminated against them on the basis of sex and sexual orientation, the HRC invoked lex specialis to say that non-discrimination articles of the ICCPR were not relevant to the case. The HRC decided that given the existence of a specific provision in the Covenant on the Right to Marriage, which is Article 23, any claim that this right had been violated must be considered only in light of this provision. This is what Article 23, Clause 2 states. The HRC interpreted this as recognizing only the marital union between a man and a woman wishing to marry each other, even when the article's text can simply be understood as men and women having the right to marry without an additional stipulation of having to marry each other. In my paper, I argue in detail that in rendering this decision, the HRC made applicable international law incoherent and hence an unreliable source for domestic court decisions. In my paper, I employ the concept of incoherence to convey one or at times even a combination of three different conceptions. First, I use incoherence to refer to situations wanting in agreement or harmony between parts of features to one another or a whole. Second, I use it to refer to variability or unevenness in the application of norms without valid explanation. And third, I use it to refer to the adoption of contradictory perspectives on an issue. In the interest of time, I'll just briefly say that Jocelyn's reasoning itself produced plenty of incoherence in international laws, non-discrimination, and lex specialis jurisprudence. It departed from settled principles of these domains without any explanation and turned non-discrimination and lex specialis into mere concepts of convenience. But this saga of incoherence does not end with Jocelyn. It continues well into post-Jocelyn developments. In the years following Jocelyn, the HRC has only made things worse. Three developments since Jocelyn that I can elaborate on afterwards if I get time have further confused the HRC's position on the relationship between ICCPR's non-discrimination obligations and recognition of queer marriages. In the beginning, my analysis showed that most marriage equality judgments have adopted the posture of evasive avoidance towards international human rights law and avoided comprehensive engagement with it. The departure from this trend noticed in Group B marriage equality judgments remains the exception. But we've seen that engagement with international human rights law is comprehensive in decriminalization judgments and in Group C marriage equality judgments. An immediately evident explanation for this could rest on the favorable or unfavorable character of international case law. But I debunk this explanation in my paper. It's not just about international case law being favorable or unfavorable. I can elaborate on that if there are any questions on why I think that's not a valid explanation. Instead, I think it is the absence of clear international legal standards on same-sex marriage under the ICCPR that explains why most marriage equality judgments focus primarily on domestic law without extensive reference to international law. Even before the post-Jocelyn developments compounded ICCPR's incoherence, domestic judges could have reasonable doubts as to the ICCPR's stance. This is on account of how disjointed and incoherent Jocelyn itself was vis-a-vis prior jurisprudence on non-discrimination and lex specialis. Jocelyn did not properly address the norm conflict between a heterosexual conception of marital rights on one hand and non-discrimination obligations on the other. Hence, uncertainty and inconsistency on what ICCPR demands explains not just why domestic courts of state parties might harbor misgivings about comprehensive engagement with international law, but also why litigating parties might harbor similar misgivings while preparing arguments. The chilling effect cast by ICCPR's incoherence on judges and litigants alike can explain why international law is largely missing from marriage equality judgments. Given how politically polarizing same-sex marriage can be, it makes sense for courts to avoid ensconcing the legitimacy of their decision in a source fraught with incoherence on the issue. Therefore, incoherence on treaty obligations more generally tracks hesitancy of domestic courts in relying on international law for deciding in favor of same-sex marriage cases. I'm not denying that other factors must have influenced the phenomenon in question as well. I'm only making the limited claim that ICCPR's incoherence is one among a bundle of factors with explanatory potential. To end, my paper's explanatory contributions are not intended to swallow up the entire explicative arena. The point to take away from this analysis really is for us to go beyond international law and see how it engages with social justice movements like the queer justice movement and domestic law. This exercise is important if you want to identify what's wrong with international law presently, and if you want to improve engagement with it at the domestic level. From this, we can draw lessons on methodology, of the way in which we study international law, and on the virtues of enhancing abstract qualities like coherence in law. Thank you.
Good afternoon. Thank you to everyone for being here today, and thank you to the American branch for organising this panel. I'm looking forward to your feedback, particularly as this is still a work in progress. Today, I want to talk about exploitation in the contemporary global fishing industry. My presentation will be in 3 parts. I want to start by detailing some of the exploitative practices associated with the fishing industry. In the second part, I want to move on to speak about jurisdiction at sea and the use of flags of convenience. And then in the final part, I want to examine how an enforcement gap has created a culture of impunity and argue for the institutionalizing of universal criminal jurisdiction over the most egregious human rights abuses. In line with the conference remit, I want to make the case for moving beyond current international law paradigms and ending the primacy of flag state jurisdiction. Seafarers and fishers have long faced exploitative practices which go far beyond the harsh working conditions, long hours, short rations, and inhospitable living environments commonly associated with maritime labour. It's perhaps unsurprising then that the contemporary global fishing industry remains a major site for human trafficking, forced labour, and debt bondage. Perhaps the most extensive reports of abuse are associated with illegal fishing operations known as IUU vessels. However, IUU vessels represent only the tip of the iceberg. The exploitation and abuse of vulnerable persons are depressingly widespread, with one International Labour Organization survey finding that at least 1/6 workers on long-haul boats had either been coerced or deceived into working against their will. Exploitation of fishers can occur at the recruitment stage, within the labour process itself, or when a worker attempts to end the employment relationship. The contracting of labour in the fishing industry has become increasingly complex, often involving a range of intermediaries and relationships with different degrees of formality. For example, the recruitment process often relies on specialised labour intermediaries known as manning agents, who frequently deceive workers about their employment conditions, promising victims they will work in a different destination country or in a completely different job category. It is only towards the end of the recruitment process, once the worker is entrapped, the true nature of the role becomes apparent. However, even those workers who have freely entered employment on fishing boats, or put differently, have not experienced deceit or physical coercion in the initial stages of the recruitment process, remain deeply vulnerable to abusive labour practices. Workers are frequently coerced into signing repressive contracts by manning agencies. The levelling of exorbitant recruitment fees is commonplace. In a situation where a worker cannot pay fees, a debt facility is provided with family assets often used as collateral. These debts are strategically maintained by fishing operatives through false accounting and extortionate levels of interest. As such, some workers find themselves already carrying unsustainable levels of debt before they begin work, effectively placing them in a position of bondage. The threat that the debt will be passed on to the debtor's family is also used to coerce a worker into remaining with the fishing vessel. This forms one of the key mechanisms for entrapping workers for extended periods of time. Beyond abusive recruitment practices, mistreatment of fishers is commonplace, with unscrupulous captains buying and selling people like chattel. As ship operators pursue maximum gain at minimal cost, fishers are prohibited from leaving the vessel through threats, intimidation, violence, and other forms of coercion. These include threats of deportation, non-payment of wages, and withholding of the employment securities that families have paid as part of the recruitment process. allegations of other serious crimes aboard vessels, including murder, have been made. Such is the high degree of control exerted over migrant fishers' bodies and living and working conditions, and so extensive are the webs of coercive practices in which they are caught up, that a strong argument can be made that circumstances can often be considered slavery under international law. Several factors are key here: the significant proportion of workers who have been trafficked, the exploitative conditions which are rife in the industry, and the captive nature of high sea fishing. So I want to move on now to briefly examine the regulation of activities taking place at sea. This is built upon a complex pattern of jurisdiction. International law divides the ocean into multiple jurisdictional spaces or zones. The spatial ambit of each jurisdictional zone is based on the distance from the coast, irrespective of the nature of the ocean and the natural resources it contains. However, since most activities at sea are carried aboard vessels, the UN Convention on the Law of the Sea, or UNCLOS, affords significant authority to the jurisdiction of the country under which a vessel is flagged. Ships, like human beings and corporations, have a nationality. Determining jurisdiction at sea is an exercise in considering together maritime zones, the type of vessel, and the specific activities carried out aboard the vessel. This jurisdictional framework makes the fulfillment of fishers' rights less than straightforward. Most migrant workers are at least present upon a state's territory. In contrast, a fisher, without leaving the boat, may find themselves under the jurisdiction of 2 or more different states on the same day. The uncertainty concerning concurrent jurisdiction is illustrated by a 2011 case of a foreign chartered fishing vessel licensed to fish in New Zealand's exclusive economic zone. Despite several reports of serious physical, verbal, and contractual abuses having occurred aboard these ships, there was uncertainty as to whether the coastal state could intervene on board vessels fishing in its economic zone, but flying the flag of another state. The preeminence of flag state jurisdiction, at least in areas beyond territorial seas, means that the flag state's laws are crucially important to the prosecution of trafficking crimes and the provision of assistance and protection to victims. For example, under international human rights law, states have a responsibility to uphold certain commitments towards the victims of exploitative practice, even where these acts are carried out by private entities seeking private gain. It is therefore of critical importance that flag states bring their national laws into accordance with international human rights treaties and take measures to enforce these laws and protect fishers' rights. While there is no doubt that many actors bear some responsibility for failing to prevent the spread of abusive practices across the fishing industry, for example, the skippers of the vessel, corporations further down the supply chain, the coastal state, the fisher's home state, the port state, and the consumer too, can all be seen as bearing some responsibility here. Nevertheless, under international law, it is flag states that are entrusted with the duty to protect workers on board vessels flying their flag and to take measures to enforce these laws and protect fishers. A number of factors have undermined this legal duty, from the spread of open registries and flags of convenience to technological developments that make it possible for vessels to spend more and more time from shore, and the depletion of global fish stocks which push vessels further out to sea. Flag of convenience countries tend not to sign up to key legal agreements protecting workers' rights and are often chosen precisely because they will not provide effective recourse for employees with grievances. As a result, many flag states find themselves unable or unwilling to exercise effective jurisdiction. This enforcement gap has created a culture of impunity, allowing operators to maximize their profit at the expense of workers' fundamental human rights. In the absence of effective jurisdiction over fishers, serious violations to their fundamental human rights aboard vessels regularly go unchallenged. In this closing section, I want to suggest one way out of this dead end. Since the application of both human rights and labor rights, since the application of both human rights and labor rights requires the existence of jurisdiction, and since flag states are either unable or unwilling to exercise this jurisdiction to protect fishers from abusive practices, we must contemplate removing the primacy of flag state jurisdiction. Such selective enforcement by flag states demands institutionalizing the practice of universal jurisdiction to end impunity, to prosecute perpetrators for slavery, trafficking people, and other forms of compulsory labor and debt bondage, and to secure much overdue justice for victims, thus circumventing the deep and seemingly insoluble issues created by flag state primacy. Excuse me. The use of the principle of universal jurisdiction to provide fishers the protections they are owed is not without precedent, As Sharif Bassouni has observed, universal jurisdiction is evident in treaty provisions for slave trafficking on the high seas, which has been equated with piracy. Universal jurisdiction arises from the use of high seas and is most effective way to combat such traffic in person. This analogy is a telling one, for if we turn to piracy, we find an existing rationale for universal jurisdiction in a situation which is not without parallels with that of labour abuses on the high seas. Universal jurisdiction over piracy has been justified as a means of compensating for the fact that pirates, quote unquote, generally do not operate within any jurisdiction. On this reading, they are, quote unquote, fair game wherever they are found because they lie beyond the bounds of any one state's jurisdiction. However, this analysis leaves something to be desired, for the familiar bases of jurisdiction often do exist in cases of piracy. While pirates are understood to have renounced all citizenship, this is the case neither for the vessels they attack nor the people on board. While the former can claim flag jurisdiction, the latter would likely be citizens of some state, allowing for nationality-based jurisdiction. The real issue here then is the same as that which emerges from efforts to check abusive practices on board fishing vessels, that of location. Like fishing, piracy often takes place on the high seas, inhibiting states' enforcement ability. In other words, no single state alone can adequately monitor pirate attacks against citizens or ships over any significant portion of the high seas. Giving any state that captures a pirate permission to assert jurisdiction can, with appropriate safeguards, create a more effective enforcement mechanism against a crime that by its nature eludes the reach of the territorial state. There is nothing in these arguments that could not equally be applied to exploitative labour uses at sea and the use of an expanded jurisdictional framework to combat these crimes. I want to close by acknowledging that any expansion of jurisdiction still requires a willingness to exercise such jurisdiction. The expansiveness of ocean space and the technical means required for visits and inspections demand cooperation at the regional and global level. Prevention is fundamental, but onerous and often impractical, requiring constant monitoring of activities, regular inspections in port and sea, and the visit of ships that are suspected of being engaged in illegal activities. This will require cooperative efforts between states to address illegal activities at sea and to protect common interests, including maritime security and conservation of resources. However, regional and international cooperation between states can frequently be hampered by geopolitical, diplomatic, and economic considerations, making the attainment of an effective enforcement mechanism a complicated task. But states' response to piracy, terrorism, and proliferation of weapons of mass destruction demonstrates that the institutional capacity already exists to prevent exploitation at sea. Thus, the campaign against exploitation in the fishing industry requires not just international cooperation to build capacity, but also a sea change in attitudes. For while states have always taken maritime security threats seriously, they have rarely shown the same interest in tackling the various kinds of abuse to which migrant workers are subjected. Sorry. Yeah, no hurry at all. Yeah. Thank you.
Hi, everybody. I wanted to thank, sorry, I don't want that sliding away on me. No. Oh, that works much better. Thank you. Hi, everyone. Thank you so much to the American branch of the International Law Association for having me. Fun fact, this was actually the first international law conference that I attended as a 1L. So it's very sentimental and surreal to be here, and I'm very excited. So I am here to talk about how AI impacts the commission of the crime of aggression under international criminal law, specifically through state cyber operations. So this idea for the paper was brought to fruition through studies of the WannaCry ransomware attack, which ransomware, for those of you who don't know, although you've probably encountered it, it shows up on your computer and say a phishing email. You click the link, and then all of a sudden the hacker is telling you that you will get your computer back if you pay them some obscene amount of money. So the WannaCry ransomware attack was basically that, but on a truly unimaginable scale. It infected computers in 150 countries, incurred about $400 billion in losses globally, and temporarily disrupted industries from telecom industries to emergency medical care. So for example, in Britain, the NHS was impacted, and one of the many harms that it caused is that it disrupted communications with ambulances, and ambulances were rerouted, people died, and that was just one small example in one of the dozens of states impacted. So the damages here as a ceiling can be pretty high. But how did this get me thinking about the topic of this paper? So the WannaCry attack was conducted by an organization called the Lazarus Group, which is a very secretive and very effective group of cyber criminals and hackers that's run by, controlled by the North Korean government. And the attack was powered by a crypto worm that was powered by AI. So that's part of how it was able to be so effective, is that the hackers didn't actually have to identify all of their targets. They didn't have to even plan with that much specificity what the attack would look like, because the AI-powered worm was able to decide at each interval how to expand the attack from computer system to computer system, allowing it to spread so quickly that by the time anyone knew what was going on, it was quite literally all over the world. So this attack got me thinking about, in the case that you can attribute those instances to states, which again, the Lazarus Group is interesting, and we'll see why that state attribution element is important in a little bit. North Korea is certainly not the only state to have a essentially hacker cell within its foreign armed forces mechanism department. Russia is another front runner in that field. So this got me thinking about how that could impact on our understanding of the elements of the crime of aggression, which of course was created long before AI was even a work of science fiction. For some context, aggression has a really long history, most notably starting around World War II and the prosecution of the Nazis. It was very slow to be implemented over the following several decades. Not even originally being included in the Rome Statute in the 90s. That was essentially punted to an interpretive body that met in 2010, and again, wasn't actually activated until 2018. So it's been a very long time coming, and we have not a lot of touch points to color how that is unfolding. And I actually am realizing I've just essentially abandoned my PowerPoint, so I'm gonna stop. I'm gonna stop holding the clicker. Oh, I lied. This would be helpful. There we go. Rather than reading you the elements of the crime of aggression, because that would be really dull, the thing that I think I want to draw attention to is, first of all, the act for a crime of aggression is the planning, preparation, initiation, or execution of an act of aggression. The perpetrator or actor has to be, crucially, a leader of a state, the state's political or military entity. It can be de jure or de facto leadership, but you do need that person in a decision-making capacity for the state. And the underlying act of aggression, which is also known as a breach of the peace, is the conduct that we are ultimately targeting. It has a very close nexus to use of force, which stirs up some issues that we'll get to also in a minute. The mens rea for the crime of aggression, though, is actually found not in Article 8 bis, which holds the rest of the definition of the crime. It is the generic mens rea found in Article 30 of the Rome Statute, which tells us that you need intent for the conduct, and what we in American criminal law classrooms would call knowledge plus, as for the necessary surrounding circumstances. So that means you can have more than knowledge, but you can't have less than knowledge. So even before the development of AI on its current scale, there's been thorough debate in the literature about what can be an act of aggression. There's the clear yeses, things that do qualify really undebatably, either because they're in the exhaustive list or they're very closely connected to it. So you have an invasion by armed forces, a blockade, a bombardment, an armed force attack on another state. And it's worth noting that those attacks can be committed with the use of AI, right? You have lethal autonomous weapon systems used by militaries. So that is an AI-assisted attack, but it falls pretty squarely within the parameter of IHL. Where this presentation differs is that we are talking about attacks that are non-kinetic in nature. So they might have kinetic effects, as we saw in England with the NHS in the WannaCry attack, but the attack itself is non-kinetic. And there is a huge debate as to whether or not that can constitute an act of aggression, whether or not AI is involved. That's sort of the elephant in the room with this paper. I address it more thoroughly, but for the sake of time, I would ask that you just live in the hypo with me and pretend that this is okay and that there's not an incredibly substantive debate in the literature about that. So we're specifically now narrowing in on talking about crimes of aggression, specifically crimes of cyber aggression that are committed with the assistance of AI, just to bring us all the way down the funnel. Even when you get there, there's still several hurdles that we have to go through here that make it really difficult to know for sure if you're able to walk that attack all the way through the crime of aggression analysis. The first issue being the anonymity of cyber. The WannaCry ransomware attack was claimed. Sometimes they are claimed. The bigger ones tend to be. That makes the thing I'm trying to do really easy when someone comes out and says, hey, it was me. But that doesn't happen a lot. You have related issues of attribution and non-state actors, because it's a lot cheaper to get into cyber attacks than it is to, say, have an army. So the actor array of possibilities here is much broader, but there are scholars that argue you can get around these definitional issues either by changing of the text itself, which the UN Security Council is empowered to do, by expanding the literal list of things that can count as an act of aggression, or you can get that through interpretive efforts by judges at the IACC. So those are arguments from Greco and Miller, respectively. But then you're still left with the meat of my paper, which is the challenges that, aggression's elements face in terms of attacks led by AI or powered by AI. Within this example, when you look at the mens rea of an act of aggression, that knowledge plus and intent aspects of it get really difficult when you consider the wide array of attacks that are capable of being committed by AI. So for this part of the paper, I borrow pretty heavily from IHL framing for different AI-powered machinery and means for performing attacks. So first, and I'm going to reframe the language here, but I'll tie them together. So for those of you familiar with IHL, you can track that with me. The first one I refer to as an AI-assisted cyber attack. So for our IHL nerds out there, that is the human in the loop AI system. So you have the AI functioning as decision support or automated decision-making assistance in the systems. But still, I think here you're able to satisfy that intent aspect pretty easily because the intent for the attack is already formed and the attack itself is already initiated by a human actor before you have the AI coming in and assisting in its execution. Second, we have AI-altered cyber attacks, which borrows from the human on the loop framing in IHL. So there you essentially have the inverse, because you have the human operator still involved in the decision-making, but it's assisting the AI as opposed to the AI assisting it. But crucially, you still do have the human actor responsible for ensuring that the system conforms with existing law and ethical norms. In this space, you start to get, I think, a little bit murky and a little bit challenging for the purposes of an act of aggression. For example, the NotPetya attack, which was conducted by Russia's version of the Lazarus group, essentially, in 2017. It was meant to target Ukraine using AI-powered malware, but the attack spread really rapidly through computer systems and ended up attacking neighboring states. So now we start to pull at those threads of what does that intent have to look like in terms of the attack itself, because again, you have an act of aggression now being incurred not only by Ukraine, but by its neighbors. And then you have the knowledge plus question of what degree of awareness did the perpetrators in Russia's cyber group have to have in perpetrating that attack in order to meet the mens rea requirements. And then lastly, you have an AI-initiated cyber attack. We've all probably seen the Terminator, so let's just really hope that we don't end up having to deal with that. But on the instance that we do, that just really throws the elements of a crime of aggression quite out the window because it's really, really unclear how you'd manage to walk through a mens rea analysis there. So you have this issue. I think this creates a sort of legal loophole where you have actors that, again, looking at aggression's history and why we've criminalized it, and the types of perpetrators that we have a very vested interest in using international criminal law to adjudicate. You have those same characters in this narrative, but they get this interesting cop-out option where through the use of AI, you can't pin the same requisite degree of mens rea on their conduct. And that is a legal vacuum that this paper seeks to address and to hopefully propose how that could be narrowed. So some proposed solutions, Marta Bow, for example, in the literature has suggested using in the context of IHL granted, a mens rea of recklessness or dolus eventualis instead of the intent and knowledge plus pairing. This paper, though, proposes actually a modulated version of mens rea which I know anyone who's ever had to draft anything related to a law is like, what is she doing? Please stop. This is going to make our job so hard. And I'm sorry. But I think it's an interesting thought experiment to walk through, that if you have this modulated version of the mens rea, you can implement, I guess you could say, more easily provable versions of mens rea as the difficulty in assessing the AI's role in the attack likewise increases. So in my model here for AI assisted attacks, you'd still, I think, keep the knowledge plus mens rea. For AI altered attacks, that's where I think Beau's recklessness model makes a lot of sense. And then for AI initiated attacks, if we ever see them, let's all hope not together, then I think it's actually worth implementing a strict liability or maybe a criminal negligence model. We've already seen that in tort law, which the paper borrows from pretty heavily. We use that for exotic animals, toxic waste, transportation of explosives. If you have a tiger at home, we don't really care if you took the utmost duty of care in what good protections you put around people's interacting with that tiger. If it sneaks out and kills your neighbor, we're going to hold you liable anyway. And you're essentially looking at something similar here. And I think, to wrap up, that this would incentivize 3 really important outcomes. The first of which is just heightened caution in the deployment of AI as a tool for cyber attacks. Second is the challenges with proving mens rea of knowledge plus gets increasingly difficult. Again, you can granulate it as AI's involvement also increases. And finally, it prevents that legal loophole or vacuum in the current liability created under AI used in cyber attacks for knowledge plus mens rea, where the sufficient mens rea would be either a lacking ability to prove the intent and hold the people that we are seeking to target with aggression accountable. So thank you so much. So.
Good afternoon, everyone. So my title is slightly misleading. Even though it's titled third-party funding, I will be focusing mainly on not-for-profit third-party funding in the context of funding in general and arbitration. So investor-state dispute settlement, or ISDS, is a fascinating and complex system. It would be entirely impossible to cover all the caveats within a consolidated publication, much less a 10-minute presentation, or more specifically, to focus on the often intense criticisms and calls to abolish the system in its entirety. Outcry and criticism of ISDS are unfortunately not without merit. The origins of the system are often linked to the desire of former colonial powers to maintain an economic advantage, or rather control, over their former territories. A system which has, in a sense, backfired against its very creators. You can think of the ECT. The intent of my research is not aimed at negating those criticisms, nor does it provide an opinion on whether the system should exist at all. Rather, it aims to examine potential loopholes in the current system and whether those who are generally at a disadvantage could ultimately utilize the current procedures in order to level the playing field with parties who are often or have access to greater economic resources. In essence, we're operating within the gray zone of investor-state dispute settlement. Not-for-profit third-party funding happens to fit within the confines of the gray zone in ISDS. It is therefore integral to explore the potential avenues of the existing system to enhance the progression of proceedings, primarily to the benefit of respondent states in their effort to enact progressive public policies, and to ensure that states have enough policy space and control over the proceedings, and more generally greater control within the system. It has become rather evident that the scales have tipped in favor of the investors, even within new generation bilateral investment treaties. We can see that they continue to enable and provide for a multitude of investor protections, even though extending these investor protections ultimately leads to legitimate governmental and policy concerns. Yet, even with all the criticism, one aspect that tends to be overlooked is the benefit that respondent states in investment dispute may gain from not-for-profit third-party funding, where the funder provider is not entitled to any direct economic benefit arising out of the award, to be more specific. Rather, providers of not-for-profit third-party funding may be motivated by factors that are not exclusively monetary in nature, such as the protection of certain state regulatory actions that come under attack by investors negatively affected by such actions. In this sense, not-for-profit third-party funding represents an opportunity for actors within ISDS to promote and safeguard the regulatory discretion of states with respect to, for example, environmental, labor, and human rights protections by providing respondent states in investment dispute settlement with greater resources to use in their defense. So what exactly is not-for-profit third-party funding, or more accurately, how do we define it? Like many processes and provisions within ISDS, there unfortunately is no consensus nor uniform understanding of not-for-profit third-party funding, which I would argue is an advantage for those willing to explore it. And the concept introduces an evolutionary means of arbitration funding, in which the primary interest is not economic or financial gain. Rather, a funder providing not-for-profit third-party funding does so not to obtain a direct profit, but to advance certain values or causes at issue or affected by the dispute. As a result, not-for-profit third-party funding may be considered a type of donation. However, the funder must still comply with the traditional stipulations and elements of third-party funding, with the only differentiation being the for-profit element. The central interest for funding distinguishes the two forms of financing, where the not-for-profit third-party funder, it is a bit of a mouthful, is no longer entitled to any economic gain that directly arises from the dispute. Instead, their interest stems from the commitment with a particular topic or subject matter involved in the proceedings. While it is yet to receive significant attention at the multilateral level, a reference to this type of funding can be found under Article 8.26 of CETA, where it alludes to not-for-profit third-party funding by reference to donations as a type of funding. However, it is imperative to note that the absence of a direct economic gain does not account for subsequent indirect economic benefits arising out of the success of a claim. So, for example, funders may support a claim in order to obtain a ruling that may establish a pertinent legal precedent that will aid in the overall goals, which will require a case-by-case analysis to determine whether the funding is truly within the confines of not-for-profit third-party funding. And we can see that with two primary examples, one being the Phillips Morris International v. Uruguay case, where the use of not-for-profit third-party funding was successful, in which it identified the right of a state to regulate, while maintaining a wide margin of appreciation for states in adopting measures that promote sustainable development and policies within the public interest, even if their BIT had no explicit reference or provision for the use of police powers. The other case being Casares de Valor v. Russian Federation. In this case, the company Manatep had sought to establish a favorable precedent in an attempt to rely on the ruling in a substantially larger shareholder dispute under the ECT. The respondent had made the argument that the claimants were not real parties to the dispute, as they did not have a good faith interest in the proceedings and constituted an abuse of the process due to the presence of the not-for-profit third-party funder. However, the tribunal rejected this argument, noting that the claimant had purchased shares in UCOS, which resulted in a direct financial gain. Juxtaposed with the first case, we see that the defining characteristic is a direct economic benefit. The system is still relatively new, and not-for-profit third-party funding remains rare, and as such, proposals for its regulation generally remain theoretical. One of the challenges with third-party funding often focus on the lack of transparency. However, in instances of not-for-profit third-party funding, the funders often inclined to voluntarily disclose and publicize their role within these cases. While not-for-profit funding is not explicitly referenced in any arbitral institutional rules, its existence and prevalence has been acknowledged through UNCITRAL Working Group 3. In the submission for procedural rules reform, the draft provisions on third-party funding contains a note to the working group to consider whether this type of funding should be included in the draft provision explicitly, as opposed to just a footnote. Consideration on its inclusion could alter the definition of third-party funding, as the working group acknowledges that not-for-profit funding often results in different issues and impacts to the ISDS regime that is different to that of traditional commercial funding. One argument that I find necessary to make is the progression for a broad and widely accepted definition, as the notion of not-for-profit requires a clear and uniform understanding, as it cannot simply be an afterthought mentioned through the inclusion of the terminology such as donation or grant, without any further consideration. Primarily must be considered whether this type of funding extends to future economic gains and whether the definition of financial benefits needs to be expanded on to include the possibility for obtaining indirect financial gain. For example, it is difficult to distinguish between genuine efforts to preserve or advance a certain value or interest through this type of funding, and whether using this form of funding as a means to secure a favorable result to establish a precedent for future claims would therefore afford the funder a financial benefit, even though directly it would not result in a new claim under the same precedent. So while in the latter case, the funder may not receive a direct financial benefit at first, they may receive one in the future, depending on the award and how it affects the state's public policies. With further ISDS regime reform and greater emphasis on transparency and disclosure obligations, the true impact of not-for-profit third-party funding may be ascertained with the publicization of those cases, which we know is a great issue within commercial arbitration as well as investment arbitration. One interesting aspect to note is that empirical data suggests that a funder will consider supporting a case if the chances of success are greater than 60%. However, data suggests that a funder's threshold significantly drops when they're investing in different areas of interest, such as disputes related to climate change, where funders have been found to be more incentivized to invest even when the case possesses a lower than 60% chance of being successful. So the primary reason for this seems to be the interest among the funders in advancing a compelling narrative and improving their reputation, not only in the public eye, but also with the host state itself. And with the ongoing COVID-19 pandemic, companies had to reevaluate how to preserve capital growth, leading to a larger number of climate change combative efforts and arbitrations. While these funders have been within the traditional system of third-party funding, the proper framing could transition them to either pro bono or not-for-profit third-party funding. By supporting respondent states or those with compelling narratives, the funders may proactively impact the larger funding market. So if firms are already engaging in domestic pro bono work, then a similar system could be implemented on an international scale through not-for-profit third-party funding. And respondent states should therefore look towards not-for-profit third-party funding as a means of possibly alleviating the burden of financing their defense against investor disputes, which are often funded by taxpayers. As a number of sustainable development regulations increase, so do the cases, where there are currently 33 known states in total that are vulnerable to investment claims if they do not move forward with their proposed fossil fuel projects. So in addition to fossil fuel ISDS claims, another topic that may open itself up to a myriad of investor concerns is palm oil. Indonesia launched a moratorium in 2018 in an attempt to prevent deforestation and other issues pertaining to sustainable palm oil production. However, it expired in September of 2021, with the new omnibus law taking its place and further expanding investor rights. However, the earlier attempts by Indonesia to make palm oil production sustainable allude to the possibility that they may undergo further policies and regulatory changes. And this is particularly important as Indonesia is attempting to engage in various IIAs with Western countries that refuse to include palm oil unless there are regulatory changes to ensure sustainability and transparency in their production, even prompting a dispute to appear before the WTO submitted by Indonesia. However, in order to strengthen domestic policies, the investors' rights expanded upon in this law may have to be retracted and or at the very least restricted. If Indonesia were to further regulate palm oil production, they may expose themselves to a multitude of investor claims, thereby prompting the question of how regulatory chill will come into play in the coming years and whether not-for-profit third-party funding could alleviate the burden placed upon states. In essence, the utilization of this form of funding is not a long-term solution when engaging with various claims, but it may alleviate the temporary burden of bearing all of the costs within ISDS proceedings. As the system is undergoing considerable reforms, not-for-profit third-party funding seems to remain as an unimpeded system without much regulatory consideration for the time being. Therefore, the only question that remains is why aren't we all looking towards not-for-profit third-party funding for the time being? Thank you.
Thank you, panelists. So we have about 5 minutes for questions or comments. Is there anyone in the audience that has a question? Go ahead.
Thanks for these were all really interesting, totally different projects. So I really enjoyed learning from all of you. Sophie's paper touched on something I know the most about, which is maritime fishing, labor atrocities. And I found interesting your discussion about universal jurisdiction. This is in your paper, disregard, but I was surprised to not hear you talk or engage more with the ILO's instruments, in particular Convention 188, which stipulates that courts should enforce the labor rights set out in the convention, irrespective of whether the flag state has ratified the convention in question. So effectively, what it's trying to get at is the very thing that you're proposing, which is a form of universal jurisdiction which stipulates to specific labor rights conditions. So that was there, and I just didn't hear it.
Sorry, can you just repeat what it?
The convention?
Yes, sorry.
Oh, Convention 188, which is work and fishing. And so this convention by the ILO is designed to basically eradicate forced labor as well as other labor atrocities on fishing vessels. And it takes into account flags of convenience. And so what it does is increase an enforcement paradigm in which the port states along a journey, both maritime under Maritime Labor Convention and fishing sectors under Convention 188, can be stopped and enforced irrespective of whether or not the flag state is ratified the convention. And so it's getting to this very thing that you propose. So I think it would be helpful for you to look at that.
Yeah, and you aren't aware of any instances of any student.
Oh, yeah. I mean, it's been in effect now since 2016. So you'll want to go on the ILO's Normlex database. They talk about the ratification, and then the supervisory body, like any other treaty body, sets out comments. And so there's discussion within that framework. But even if you just Google and like secondary research, Convention 188 and fishing sector, you'll probably see a pretty robust literature at this point on how these instruments, the Maritime Labor Convention and C-188, are effectively trying to establish universal jurisdiction for fishing and maritime rights.
And then these are enforced within domestic ports.
So they're enforced by the ILO.
Okay.
So when a country ratifies a convention, what it undertakes is not only as the flag state, but also as the port state.
Sure.
To ensure that labor rights are being complied with, irrespective of the flag state passing through their jurisdiction.
Okay, and then in terms of a prosecution, then how?
Well, then you're down to like the UN the treaty bodies and what the ILO can and cannot do. However, what it stipulates in Convention 188 is that in fact the port state can detain the fishing vessel or the shipping vessel and not release it until the violations have been cured. And otherwise, that they have to report to the flag state and they report to the ILO Director General.
Then has there been any incident of that sort of leading to prosecution?
That I cannot answer for you. You have to think with that one.
No, but that's really helpful as well. Thank you.
Any other questions? William, go ahead.
This is so interesting. Thank you. Presenting, did the independent expert on sexual orientation make any response to the Jocelyn case, just given how problematic it was? And I'm just curious whether any other human rights bodies have expressed concerns about that decision and whether that might move the HRC in future cases to better address that topic. And then just for Christine, you're focusing on cybercrimes as it relates to the internet and to using that type of system. And I'm just curious, what about autonomous weapon systems that are unrelated to internet or worms or viruses? And so I'm just wondering, is your approach something that can also apply to autonomous drones that are independent, autonomous, they're let go into the world and they cause harm? Is there something unique about your approach that wouldn't apply to those types of kinetic type of systems? Is it only applicable to the types of viruses and programs you're focusing on?
So Jaideep, why don't you take that first and then Christine.
So to my knowledge, the independent expert has not expressed any opposition to Jocelyn v. New Zealand. In fact, no human rights body or any other UN-related body has ever questioned the continuing authority of Jocelyn, other than one concurring opinion in one of these Australian cases, CB Australia, where committee member Sarah Cleveland's concurring opinion questioned the validity of Jocelyn. But other than that, no case, no report, no speech has ever questioned the continuing authority of Jocelyn. And that's really the problem, because the Human Rights Committee between 2017 to 2022 sent concluding observations to 11 states to recognize same-sex marriage as part of their non-discrimination obligations, which is a position completely contradicting Jocelyn's reasoning. But at the same time, it did not include the stipulation in the concluding observation sent during the same period to 24 states. And there's no way you can explain this patchiness or selectiveness in including the stipulation other than say, you can't even say that these states were the ones where it's still a crime to be gay, because these states weren't the ones where it's still a crime to be gay. So really the natural next step should have been marriage equality and a stipulation to that effect in the concluding observations, but the HRC still decided to fuel opposition In fact, even in light of recent decisions, as recent as 2019 and 2022 from Hong Kong and the UK's Privy Council, upholding the rejection of marriage equality pleas by relying on Jocelyn as representative of the HRC's proposition, the HRC has remained silent, even in light of this recent reliance on Jocelyn. So I don't really see the HRC doing anything different. I was hoping to take India to the Human Rights Committee to get Jocelyn reversed, because right before I boarded my flight for this conference, we lost the Supreme Court case in marriage equality. I worked on the case, but India hasn't ratified the first optional protocol, and so I can't really access the complaints mechanism on behalf of any of the litigants.
Christine?
Yeah, thank you so much for your question. I don't know if this is on. Yeah, you can hear me. Yeah, that's fine. Thank you so much for your question. It's a very good one. In the interest of time, I'll just address two aspects of it. The first is in terms of scope of the paper, it is beyond the laws generally are, lethal autonomous weapon systems are beyond the scope of what my paper looks at. As a concept, I would say, I mean, yes, the modulated mens rea system that I had proposed could definitely be applied in other contexts. I think there's already part of the void that the paper sought to address is that there is a pretty, I think, substantial literature already in the context of IHL on kinetic attacks and the use of AI-assisted, AI-powered autonomous lethal weapons when they're used as part of a state's military activity. And also you don't have that threshold issue of whether or not something arises to an armed attack, which is a much more explicit and frankly much more convoluted question in the context of both jus ad bellum and jus in bello. So it's, yeah, mostly for scope purposes, just something that my paper avoided completely because I'd be writing an American law review length article on it, and that was just something I was about to undertake. But as a concept, sort of the second point, yes, it's definitely possible, and I think it actually doesn't stop there. I mean, the more we see AI used in different events in day-to-day life, I mean, you could map it onto a domestic criminal context as well. Something when you're looking at criminal liability for, I don't know, manslaughter with motor vehicle accident, that kind of thing, to the point we have AI assisting electronic car direction and things like that. There's not really a ceiling. It's just, I think we have to wait for the tech to develop to see where it starts to take seed. And then unfortunately, actually, I think because of the retroactive nature of legal development, you're going to see more gap filling in that regard rather than theorizing that system up front. So I might circle back to you in several years when we see how that develops a bit more. But thank you.
All right, so we are out of time. We're actually over time. Sorry about that. But thank you all for attending this panel. Thank you to our panelists for these great and diverse presentations. And can you guys stay for a picture? Oh, sure.